Hello everyone. In this presentation, an attempt would be made to explain the protection that is provided by Article 22 in certain cases against arrest and detention. Article 22 consists of two parts. The first part consists of three clauses 1, 2 and 3, dealing with rights to an arrested person, and the second part consists of four clauses 4 to 7, providing safeguards to the persons detained under a law of preventive detention. Initially, when Article 22 came up for interpretation before the Supreme Court in A.K. Gopalan v. State of Madras, where the validity of the Preventive Detention Act 1950 was challenged on the ground that it contravened Articles 13, 19, 21 and 22 of the Constitution, the court held that Article 22 was a self-contained code on preventive detention and could not be controlled by Article 21, and the principle underlying Article 21 was kept in view in Article 22, and there was no conflict between these articles. This position changed since Maneka Gandhi case. The matters on which Article 22 was silent now draw their content from Article 21. This means that the laws relating to preventive detention have to conform to the requirements of Article 21 in addition to those of Article 22, so far as they are not inconsistent with the express provisions of Article 22. Coming to the details of Article 22, under clauses 1 and 2 of the article, four rights have been conferred on a person who has been arrested. Firstly, he shall not be detained in custody without being informed as soon as may be of the grounds of his arrest. If information is delayed, there must be some reasonable ground justified by the circumstances. Secondly, he shall have the right to consult and to be represented by a lawyer of his own choice. This right is not lost if he is released on bail. Thirdly, every person who has been arrested has the right to be produced before the nearest magistrate within 24 hours of his arrest. In computing this period of 24 hours, the time spent on journey from the place of arrest to the court of the magistrate has to be excluded. This requirement is dispensed with if the person arrested is admitted to bail. Fourthly, he is not to be detained in custody beyond 24 hours without the authority of the court. Even if an accused was initially illegally detained, the detention became lawful when subsequently he was arrested and produced before a magistrate within 24 hours. But where remand orders are obtained by the police from the magistrate or a judge without producing the arrested person before such magistrate or judge within 24 hours, Clause 2 of Article 22 is violated. The two requirements of Clause 1 of Article 22 are meant to offer the earliest opportunity to the arrested person to remove any mistake, misapprehension, or misunderstanding in the mind of the arresting authority, and also to know exactly what the accusation against him is, so that he can exercise the second right, that is, of consulting a legal practitioner of his choice and to be defended by him. Clause 2 of Article 22 provides the next and the most material safeguard that the arrested person must be produced before a magistrate within 24 hours of such arrest, so that an independent authority exercising judicial powers may without delay apply its mind to his case. The Criminal Procedure Code contains analogous provisions, but constitution makers were anxious to make these safeguards an integral part of the fundamental rights. In view of wide misuse of power of arrest and detention resulting in custodial violence, including custodial deaths in police custody, the Supreme Court in D.K. Basu v. State of West Bengal has given detailed directions for arrest and detention in police custody to be followed by the concerned authorities, which have subsequently been incorporated in the Criminal Procedure Code, that is, the Bharatiya Nagarik Suraksha Samhita. The court also recognized the right of the arrestee against torture and his entitlement to compensation for its violation. Clause 3 enacts two exceptions. The fundamental rights guaranteed to arrested persons by Clauses 1 and 2 do not apply to enemy aliens and to persons arrested or detained under any law providing for preventive detention. Clauses 4 to 7 of Article 22 relate to preventive detention. The subject of preventive detention is mentioned in the union list as well as in the concurrent list, and hence both the center and the states can have their own laws. Where there is a conflict, it is the central law that prevails. Preventive detention differs from punitive detention both in respect of its purpose and justification. The object of preventive detention is not punishment for having done something, but to stop him before he does it and to prevent him from doing it. No offense is proved, nor any charge formulated. The justification of such detention is suspicion or reasonable likelihood of the future commission of the harmful act, and not criminal conviction, which can only be justified by legal evidence. In Draupadi Devi versus Union of India, the Supreme Court held that there is no constitutional mandate that preventive detention could not be utilized for an act which was not a crime. Though an act is not declared an offense under the law, if the act is illegal and prejudicial to the state's security, the law can provide preventive detention for such an act. Preventive detention is not a regulation, it is something more serious as it takes away the liberty of a person but is accepted to prevent danger to the community. Now, how about the safeguards provided to the detainees? The constitution makers recognized the necessity of laws as to preventive detention and provided in clauses 4 to 7 of Article 22 certain safeguards to tone down their harshness by placing fetters on legislative power conferred on the legislature and to prevent misuse of the power by the executive. These safeguards do not exclude those provided under other fundamental rights and are clearly guided by Articles 14, 19 and 21. Clause 4a of Article 22 states that no law providing for preventive detention shall authorize the detention of a person for a longer period than 3 months unless an advisory board constituted of persons who are or have been or are qualified to be High Court judges has reported before the expiration of the said period of 3 months that there is, in its opinion, sufficient cause for such detention. If the board reports that the detention is not justified, the government is duty bound to revoke the detention order. If the board reports that the detention is justified, the detaining authorities have to determine the period of detention, and the board cannot express any opinion as to how much longer than 3 months the detainee should be kept in detention. Even where the advisory board reports that the detention is justified, there is a protection against indefinite continuation of the detention. The proviso to clause 4a lays down that the detention cannot in any case exceed beyond the maximum period prescribed by a law made by the Parliament under clause 7b for that class of detainees. In case the opinion of the board is not obtained within 3 months of detention, the detention becomes illegal and the detainee is entitled to be released even though the opinion of the board has been obtained within 3 months of a second order of detention, revoking the first and authorizing the continuation of the detention on the same ground on which the original detention was made. The requirement of the advisory board can be dispensed with in 2 cases. 1. When the detention is not to exceed the period of 3 months, and 2. When the Parliament by law prescribes the circumstances under which and the class or classes of cases in which a person may be detained for a period longer than 3 months under any law providing for preventive detention without obtaining the opinion of an advisory board. Now, clause 5 of Article 22 gives 2 rights to the detainee. First, he has the right to be communicated the grounds on which the order of detention has been made against him, and that is to be done as soon as may be. Communication here means imparting to the detainee sufficient knowledge of all the grounds of detention which are in the nature of charges against him. The grounds for making the order are the reasons on which the detaining authority was satisfied that it was necessary to make the order. Grounds not only include the narration or conclusions of facts, but also all materials on which those facts or conclusions which constitute the grounds are based. However, according to clause 6, the authority need not disclose such facts which the authority considers to be against the public interest to disclose. The grounds supplied should not be vague or irrelevant. The other right which the detainee has been given is that he should be afforded the earliest opportunity of making a representation against the order. But without getting full information sufficient to make a representation against the order of detention, it is not possible for the detainee to make a representation, and hence he should be furnished with particulars of the grounds of his detention sufficient to enable him to make a representation, which on being considered may give him relief. He should be supplied with the documents on which the detention is based, and any delay in supplying these documents results in setting aside the order of detention. The right to have an opportunity to make an effective representation has been afforded or not depends on the facts and circumstances of each case. The representation, when made, should be considered and disposed as expeditiously as possible. No rigid time limit can be fixed within which the government has to consider the representation, and the question has to be determined on the facts and circumstances of each case. Any unreasonable delay has to be satisfactorily explained by the detaining authority. If not, the detention will be invalid. The explanation for delay should not be vague. Power is given under Clause 7C to the Parliament to prescribe the procedure to be followed by an advisory board in an inquiry under Clause 4A. The board is not a judicial or quasi-judicial body, and therefore it is not bound to follow the procedures required for such bodies. The board is in the nature of a body charged with the responsibility of advising the executive in regard to cases of preventive detention for more than 3 months. The procedure should not be unjust or hazardous. In State of Bombay versus Atmaram Sridhar Vaidya, the Supreme Court held that Article 22 laid down the permissible limits of the legislation empowering preventive detention and prescribed the minimum procedure that has to be included in any law providing for preventive detention. When such procedure was not followed, the detention would not be in accordance with the procedure established by law and thereby infringes the fundamental rights of the detainee guaranteed under Articles 21 and 22(5). In Narendra Purushottam Umrao versus B.B. Gujral, the Supreme Court held that when the liberty of the subject was involved, whether it was under the Preventive Detention Act or the Maintenance of Internal Security Act or the Conservation of Foreign Exchange and Prevention of Smuggling Activities Act or any other law providing for preventive detention, the court was duty-bound to satisfy itself that all the safeguards provided by the law had been scrupulously observed and that the detainee was not deprived of his personal liberty without the authority of law. In Abdul Jabbar versus State of Rajasthan, the Supreme Court held that a detainee had a right to be represented by a friend who was not a legal practitioner. Denial of such a right would amount to non-compliance with the procedure by the board, and this would vitiate the entire proceedings before it and render continued detention of the detainee illegal. Thus, in view of what has been laid down in Maneka Gandhi and in a number of other cases following the decision, the law of preventive detention has now to satisfy a twofold test. One, that the protection and guarantee afforded under Article 22(5) is complied with, and two, that the procedure is just and reasonable. The board must conclude its proceedings expeditiously and must express its opinion within the time prescribed by law, failing which the detention would be invalid. Along with its opinion, the board must forward the entire record of proceedings before it to the government because the government is supposed to take a decision after perusing the entire record. Where the decision is taken without going through such record, the detention would be illegal for non-application of mind. It is for the legislature and the executive to lay down a detailed code in respect of the treatment of persons under preventive detention. However, in A.K. Roy versus Union of India, the court held that it can always examine individual complaints of ill treatment. A detainee has to be normally kept in detention in a place which is within the environs of his or her ordinary place of residence, though ordinarily the place of detention is a matter for the administrative choice of the detaining authority, and a court would be justified in interfering with that decision only if it was in violation of any specific provision of the law or was vitiated by arbitrary considerations and malefides. The detaining authority must inform the relatives of the detainee in writing the fact of detention and the place to which the detainee is transferred during the course of his detention. Now, can a person who is already in jail be detained under a preventive detention law? The Supreme Court in Hudrom Kanunjao Singh versus State of Manipur held that there was no prohibition in law to pass the detention order in respect of a person who was already in custody in respect of a criminal case. But if the detention order is challenged, the detaining authority must satisfy the court that the authority was fully aware of the fact that the detainee was actually in custody, that there was reliable material before the said authority on the basis of which it could have reasons to believe that there was real possibility of the detainee's release on bail, and further, on being released, he would probably indulge in activities which are prejudicial to public order, and in view of the above, the authority felt that in order to prevent him from indulging in such activities, detention order was necessary. In State of Tamil Nadu versus Nabila, the Supreme Court held that the laws of preventive detention should be strictly interpreted and the procedure provided must be meticulously complied with. Therefore, the object of the law of preventive detention is not punitive but only preventive. In case of preventive detention, there is no need to prove an offense or frame a charge. Mere reasonable suspicion can justify such detention. However, the civil and constitutional rights guaranteed to every citizen by Article 21 of the Constitution must be borne in mind by the detaining authority while passing the order of detention, because no person shall be deprived of his life or personal liberty except according to the procedure established by law. This, in brief, is about the various safeguards provided to an arrestee and a detainee under Article 22 of the Constitution. Thank you.